You've packed your bags, found a new home, maybe even landed a great new job. But before you move your kids, stop, because one wrong move, even with the best intentions, could completely destroy your custody rights. Every year, countless parents think they're redoing what's best for their children, moving to a safer neighborhood, finding better schools, or chasing new opportunities. But the law often sees things very differently. In the eyes of the court, moving your child, even for perfectly good reasons, can be interpreted as violating a custody agreement or intentionally denying the other parent their visitation rights. So, before you make that life-changing move, let's unwrap the legal truth about relocating with your kids after a separation or divorce. This is Law Unwrapped, where we simplify the law to protect your future. Let's dive right into the first and most critical rule. Step 1. You can't just move without permission. This is a huge one. Even if you have primary physical custody, you almost always cannot just pack up and move your child to another city, state, or country without either the court's approval or the other parent's explicit written consent. The court's primary concern, its guiding star in every decision, is always the same question. Is this move truly in the child's best interest, or is it just in the parent's best interest? The distinction is crucial. If you move without getting the proper authorization, the other parent has serious legal options. They can file a motion for contempt of court, ask the judge to completely change the custody arrangement, or even demand the immediate return of the child. Remember this key takeaway. Good intentions do protect you in family court. Following the proper legal procedure does. This brings us to step number 2, the formal notice requirements. You can't just mention your move in a text message. Most jurisdictions have strict rules that require you to give formal, written notice to the other parent before you relocate. This isn't just a suggestion. It's a legal obligation. Your written notice typically needs to include specific details, like your new address, a clear reason for the move, and information about the new school your child will attend. And you have to provide this notice well in advance. Usually, the law requires anywhere from 30 to 90 days notice before your planned moving date. Why is this so important? If you skip this step, you immediately lose credibility with the judge. The court might see your failure to notify as a deliberate attempt to hide the move and cut the other parent out of your child's life. It paints you as uncooperative and secretive, which is the last thing you want when your custody is on the line. Now, let's talk about step 3, how the court balances your rights versus the child's stability. When you file a request to relocate, the judge won't just rubber stamp it. They will perform a careful balancing act, weighing several important factors. They'll look at why you're moving. Is it for a better job that will significantly improve your child's quality of life? Are you moving to be closer to a support system, like family? Or are you moving for a new relationship? The reason matters. The court will also heavily scrutinize the child's existing relationship with both parents. If the child has a strong, active bond with the other parent, the court will be very hesitant to approve a move that disrupts that. The distance of the move is another huge factor. Moving across town is one thing. Moving across the country is another matter entirely. The judge will want to know if you've explored any alternatives. Could you have found a similar job closer to home? Have you proposed a new parenting plan that makes long-distance travel feasible? If the move will undeniably harm the child's relationship with the other parent, you will need to provide very strong, compelling proof that the move is still in the child's best interest despite that harm. For example, if you're moving for a fantastic job that doubles your income and allows you to afford a better home and education, that's a valid argument. But if that same move makes it nearly impossible for the other parent to see their child, you'll need to present a rock-solid, detailed parenting plan to show how you'll overcome that distance. This leads us to step 4, and it's a procedural one you cannot ignore. Modify the custody order first. The biggest mistake you can make is to move first and hope to explain it to a judge later. That is a recipe for disaster. The smart, legally sound approach is to file a formal request to modify the custody or visitation order before you relocate. Doing this shows the judge that you respect the law and the court's authority. It proves you're being transparent and following the rules, not trying to evade them. If you move without approval, you risk being seen as uncooperative, defiant, and in contempt of court. Even if your move is intended to be temporary, you should always document it and, if possible, get an agreement in writing. Proactive communication and documentation are your best friends in family court. To make your case stronger, you need step 5. Build a comprehensive relocation plan. When you file your request with the court, don't just say you're moving. You need to present a detailed, thoughtful relocation plan. This is your chance to show the judge that you have thought through every aspect of this decision from the child's perspective. Your plan should clearly outline the reasons for the move, with supporting evidence if possible. It should include details about your new home and the new school district. Most importantly, it needs to lay out exactly how you will support and facilitate the child's relationship with the other parent. How will you make sure they stay involved? Propose a schedule for regular video calls. a plan for travel and visits during holidays and summer breaks, and how you'll share costs. Judges respect parents who plan, not parents who hide. A well-crafted plan proves that your move isn't about running away from your ex. It's about responsibly moving forward for your child's benefit. And that brings us to a modern twist in family law. Step number 6. Virtual visitation is now a game changer, especially in a post-2020 world. Courts are not just open to technology. They expect parents to use it. Video calls, shared family apps, and other forms of virtual communication are now considered standard tools for co-parenting. When you're proposing a long-distance move, offering a robust virtual visitation plan can significantly help your case. It shows the judge that even though you'll be physically distant, you are committed to keeping the child's bond with the other parent alive and strong. You're not cutting ties. You're just adapting them to the new circumstances using modern technology. This can be a very persuasive point in your favor. Finally, we arrive at step 7, which is a rule for your own conduct. Never ignore the other parent's rights. Even if your ex is being difficult, uncooperative, or completely unreasonable, do not sink to that level. It's crucial that you don't give the court any reason to side with them. Meticulously document every single attempt you make to communicate. Save every text, email, and a log of your phone calls. Always use a polite and businesslike tone. Courts reward parents who act with transparency, maturity, and in good faith. If your ex ultimately refuses to give their consent for the move, that's okay. Let them. The final decision doesn't rest with them, it rests with the judge. And the judge will decide based on the facts and what is truly best for the child, not on what is easiest for either parent. So, let's wrap this up. Moving with your kids might seem like the key to changing your life for the better, but if you do it wrong, it can change your custody arrangement forever, and not in a good way. Before you even think about packing a single box, make sure your move is legal. The wisest first step is always to talk to a family lawyer in your jurisdiction. They can guide you through the specific requirements of your state or province. File the right paperwork, build a strong case, and protect your relationship with your child by doing things the right way. Because in the world of family law, it's a tragic but true fact that good parents can still lose custody not because they were bad people, but simply because they didn't follow the rules. This has been Law Unwrapped, simplifying the law to protect your family. Thank you for watching. If you found this information helpful, please give this video a thumbs up. Subscribe to the channel for more legal insights, and hit that notification bell so you never miss an update. We'll see you next time.